Hi everyone, a very good evening to all of you and welcome to the live virtual classes of Board of Studies ICAI CA Intermediate course. We are discussing about incorporation of company and matters incidental thereto. This is the third session of this particular topic under paper 2, that is corporate and other laws. I am Dr. Vijay Kumar Singh and we will be talking about today's session and completing this chapter. We already had two chapters, so we will have a quick recap of that on 23rd and 25th of September, which you would recollect. So we began with our discussion in detail. But before I proceed with the recap of sessions, some housing announcements. Today, your chat is not enabled, so you cannot post your questions in the chat box of Zoom. However, you can post your questions in the admin in your panel or the portal for which you have been given an access to. Like, for example, Pranav has asked a question. So similarly, you can use that particular portal for asking your questions. However, for the benefit of people who are not connected to the portal and would like to ask some questions, I will enable a window. In that particular window, you can raise your hand and then I will allow you to speak and then you can ask your questions. This is how we will follow so that there is a proper process in which we have the lecture and you can also ask questions then, right? I hope this is fine with you all. Can I have a yes if you have understood this on the portal?
Yeah, sure.
Okay, great. So now we move ahead and talk about the recap of the session. What we are trying to say here is here we are trying to see the different topics which we have covered so far. Okay, on 23rd of September and 25th of September. This is we dealt with and we started with the role and position of promoters. This is how we began. And we understood the role of promoters and also the pre-incorporation contracts. While we were discussing about these sessions, I had told you about some additional information because additional information makes your understanding very, very clear. Then we began with section 3, which basically deals with formation of a company. And while for talking about this, we also dealt with in detail the different types of company because all these different types of company have a different mechanism of different mechanism of forming the company or different mechanism of incorporating the company. Like, for example, guarantee company, there are some different procedures. One person company, definitely there are different procedures because you have to provide for a nominee. So these things which we discussed. Then we also saw section 3A, which talks about members who are severally liable, in particularly in cases where the number of members goes down than the statutory limit. So can you tell which is the statutory limit of the statutory limit of your companies? What is the statutory limit, private and public? Can you tell that? You can utilize the dashboard for your answers. So please use the question list there. You can put your answers in your portal. Okay, the portal access which has been provided to you. So you have to simultaneously flip between these two so that your questions are recorded there. Then we talked about so members if reduces less than 2 in case of private company and less than 7 in case of public company. Then in that situation, the members are individually and personally liable for it because they are not meeting the requirement of a statutory minimum. However, we saw that there is a 6-month period before this provision gets, into force. Now we also saw section 7, which talks about incorporation of a company, and we saw the list of documents which are required for incorporating a company. And that particular list was a quite detailed list which we had a look at. Okay. And then we also saw the procedural requirements. Though procedural requirements in detail is not part of your syllabus, but still we have talked about the SPICE E plus, INC 32, INC 1, and different other forms. In fact, I uploaded the list of forms also in your portal. You can have an access to. I have shared the presentation of both these days with you people. So people who were not present in the session could, could basically go through that particular presentation which has been shared with you. And section 9 we saw, which basically talks about effect of registration, a very, very important section, which actually gives birth to a company. In fiction, the company gets born and then thereafter it has its own personality independent of its members who have formed it. So quite an interesting, scenario where a new company is born. So the effect of registration is that it gets power to own property. It gets power to sue, be sued. It gets power to, recruit people. So all these things happens because of the registration, and a registration certificate is issued by the registrar of companies. And then thereafter, the company has its own independent existence. So we saw this very, very clearly. We also saw the declaration on commencement of business. So there is a requirement of declaration on commencement of business under section 10A. We also saw the history of this particular section. Initially, it was there, then it was removed, and then it was brought back under the Companies Act. And this thing we have seen. You can also watch the recording of our previous session wherein we discussed this in detail. Other than this, we also talked about many additional information like, the history of companies. We saw the, joint stock companies. These things we discussed. And then we had addressed the questions and clarifications from you people. On 25th, we discussed about the company which are getting incorporated by fraud. So application of section 447, that is talking about corporate fraud. We discussed that in detail. And then we discussed about section 8 companies which gets incorporated for the purposes of charity, etc. And also we saw in which situations the section 8 license could be revoked. So this is an important element which we discussed. Then we briefly touched upon incorporation forms, and I shared a document around this. Then we moved on to the constitutional documents of a company, that is memorandum of association under section 4. We saw different clauses under the memorandum of association, precisely 5 clauses plus additional clauses in case of one-person company that you would recollect. Okay. What is that additional clause in case of one-person company? If anyone can put it across in the dashboard. A lot of people have answered here. Tejaswini, Pranav, Tejas, Shruti, Manoj, Palchandar. Yes, go ahead. Can you put your answers here? What is the additional requirement in case of a one-person company in memorandum of association? Yes. Yes, nominee clause. Very good. So, Tejaswini, subscription clause is there, but subscription clause is applicable to everyone. But in case of one-person company, there is an additional requirement of nominee clause because there is a single person, one-person company. So when he dies or something wrong happens, then what would be the situation? Nominee should take over. This is what was the requirement which we saw. Then we saw important doctrine, that is doctrine of constructive notice. We also saw the doctrine of ultra vires, as well as we saw the other doctrines. This is something which we discussed in detail, right? Then we saw section 16, which basically talks about rectification of name of the company, which is different than alteration of memorandum of association and articles of association. Then we discussed about articles of association and major important clauses which are there in articles of association under section 5. In particular, we discussed about entrenchment provisions, which we are going to cover today as well. We will have a brief overview about it. And then we talk about section 10, which deals with effect of MOA, that is memorandum of association, and articles of association. And then ultimately, we saw a detailed analysis or discussion on registered office of a company. And we have seen that what is the rationale for putting so much of focus on registered office of a company. We saw different frauds which company may commit by having so many companies registered at one place. Nowadays, there is a requirement of physical verification and geotagging, all those particular things which we discussed in our previous session. So this is the recap of the previous session in chapter 2 of the Companies Act. Now what remains is alteration of memorandum of association and certain ancillary provision, which we are going to touch upon in today's class. Now, if you will see in terms of learning outcomes, this is what we have already covered, the red ones. Today, we are going to talk about changes in memorandum of association and articles of association. Also, we will see that how documents may be served in case of companies, because it is not a natural person. So to whom to serve, who will serve, how the service of documents will considered legal. And then we will also talk about who is authorized to authenticate the documents and proceedings or contracts, or in case of execution of bills of exchange check, who is the person who is going to do. These are the points which we are going to discuss today. Other than that, in our previous two sessions, you had some questions to me about how to prepare for the examination. So I did a bit of a study on this dimension, looked at your syllabus, looked at some questions which are there in previous years. And I have come to the conclusion that you have to strategize as per the syllabus and the weightages of different portions, right? So you have to find out what is the weightage of this topic or this whole section. Accordingly, you have to put your efforts in preparation of the examination. And it is here important for you to bifurcate these topics into it. One tool which I utilize for my reading and understanding is basically writing the questions and then the answers. So on each of these topics, you have to prepare some possible questions. While preparing that questions, you also know what would be the answer and make it point wise. So that preparation will always help you remember those things as well as brush them when you are, towards the examination. When you come near to the examination, it becomes useful for you. By the way, these topics are important topics. When you will work also after clearing your examination, these notes will be very, very useful to you. So my advice to you would be that you prepare your own notes, referring to different sources. There are plenty of sources available now to you people, but what happens is these sources are developed as per the design or methodology of respective persons, and that may not suit your learning style. So everybody has a different learning style, so you should plan your learning as per your own learning style. Try to frame some short answers and also the objective answers, and keep your own notes. This is what would be my advice to you as far as preparation is concerned, right? So this is the point. So Neha, you can ask your question here itself as you have put this query. I am flipping between these two, screens so that I can just look at your questions and keep answering them while I speak. I will open up a window because you joined late probably. I have already told I will open up a small window wherein you can raise your questions and then I can answer your questions. Okay. This is how we will go in the flow. I hope this clarifies the point. Let us now move ahead. Now, today we are going to talk about alteration of memorandum, which has been provided in section 13 of the Act. Now, you must note that there is a lot of transformation which has happened in the company law over the years. One of the important transformation which has happened is that it has made easier for the companies now to alter the memorandum. If you will go back to the days prior to 2013 or even prior to that, the alteration of memorandum was a difficult task. Why? Because they thought that once memorandum is made, then you should not alter it many times. It becomes, it gives a different impression for people who have invested in the company. But over the period, things have changed and the principle of ultra vires has also diluted. Initially, the principle of ultra vires was very rigid, very strict. If you recollect the Ashbury railway carriage case. So those things have changed over the years. We are now talking about ease of doing business. We are talking about openness. We are talking about more flexibility to the companies. And hence, the procedure for alteration of things have been changed. And now it has become more user-friendly to the companies. However, at the same time, they are trying to make the balance Balance for what? Balance for fairness, balance for equity. So they want to give, freedom to the companies to alter the memorandum and articles, but at the same time, they want to also put a bit of a check and balance so that they do not defraud anyone, or they do not take away the, take advantage of this. So this is a very, very important aspect which needs to be taken into consideration. Now let me have a look at this provision, section 13. Okay. And section 13 says that save as provided in section 61, right? So section 61 basically deals with power of limited company to alter its share capital. So whenever there will be a change in the capital clause, or there will be an alteration of capital, it has to be dealt with by way of section 61 of the Companies Act, which is part of share capital and debentures. This session, we are going to have a separate detailed session, 3 sessions we are going to have on share capital and securities. There we will touch upon this section 61 in quite detail. For the time being, just remember this, and if you find time, go through section 61. This will give you an understanding how a limited company has power to alter its share capital. Alteration of share capital involves many things. Alteration can be by, merging some shares. Alteration can be dividing shares. Alteration can be buying back shares. Alteration can be, issuing employee stock option. There can be many ways by which the share capital can be altered. So this particular dimension we will see in the class where we cover that. But for the purpose of alteration of memorandum, this will be covered under section 61. There is no specific provision for alteration of share capital under section 13. That is why it is said save as provided in section 61. So there is a requirement, a mandatory requirement of special resolution in case of companies. So whenever there is an alteration of memorandum, there is a requirement of a special resolution. What do you mean by special resolution? Special resolution is different than ordinary resolution. Ordinary resolution is decided by majority of the people who are voting. Special resolution is meaning that minimum 2/3 of the members, or 2/3 of the class of members are voting for the resolution. That becomes the special resolution. So requirement here is a bit stringent. So you cannot pass a memorandum change by way of just ordinary resolution, but there is a requirement of a special resolution. As well as one has to follow all procedures which are given in incorporation rules, which needs to be followed here. Now, altering the provisions of the memorandum can be done by this particular method. So what are the requirements? What are the basic requirements? Basic requirements are that there should be a special resolution, and this special resolution has to comply with the procedure. There are some procedures, like for example, all creditors should give a assent to, members should, give, there should be a special resolution, there should be a board resolution. All these things are taken into consideration while looking at the provisions of alteration of memorandum. Now, alteration of memorandum, as we looked at, memorandum has different clauses, right? Could you name the clauses? The 2 clauses we have already discussed, right? One is, we are talking about share capital. The other one we are talking about change in name. So change in name, when we are talking about, is basically the any change in the name of a company shall be subject to the provisions of subsection 2 and 3 of section 4, which basically deals with memorandum of association, and shall not have effect except with the approval of the central government in writing. So the change in name has to be basically dealt with by way of the provisions which are given in section 4 of the Act, as well as we saw there can be a rectification in name by the central government. We will talk about it in a while. But any change in name has to have an approval of the central government, right? Herein, in this situation, central government is defined, and for change in name, generally it is ROC, and if it is change in name which relates to rectification, it is the regional director. This is how it works. So you have to basically, get the permission of the central government in writing for effecting the change in name. However, in case of the change which is only to make a change from public to private, because you must be knowing that a public limited company has to not mention, just they have to mention limited. And in case of private limited company, private has to be mentioned. So if there is a change only because of this, then in that situation, the private word change will not be considered as the conversion of as the change. So that is what it is saying. So it says, provided that no such approval shall be necessary, where the only change in the name of the company is deletion therefrom the word private. So what you are doing, name is remaining same, except that you are adding private to a public company, and that addition of word private does not change the name of a company. This is what is the requirement. In case of company which are listed before the stock exchange, then they have to also comply with additional requirements of listed companies, that is SEBI listing obligation and disclosure requirements, that is LODR. So SEBI LODR additional requirements are mentioned there, which needs to be followed by the listed company in case of change in name, which basically involves informing the stock exchange, and some other procedural requirements are mentioned, which needs to be complied with by the company. Now, yes, Purva Das, you keep typing your questions. I have got some questions. I will answer all these together. Okay. Now, if you see, the third subclause of this section says, when any change in the name of a company is made under the subsection 2, the registrar shall enter the new name in the register of companies, and they will be issuing a fresh certificate of incorporation. So whenever there will be a change in the name of a company, a new certificate of incorporation shall be given to the company, and the new change or the new name will only get effective on the issuance of that certificate. So one cannot use the name of a new company, just because you have changed the name, you go ahead with that. You need to have the certificate which is issued by the registrar of companies to get this effective. Okay. So this is the requirement of change in name. So this is the change in name clause or change in name requirement or alteration of the memorandum. So as you see, there is no requirement of central government approval when there is a small change like private to public, though it is not a small change, actually it is a big change. But since we are not changing the name effectively, so there is no requirement of a central government approval, because see, if you are changing the name, there are multiple things which happens, right? So there may be a fraud, and that is why you are changing the name, or there may be a trademark violation, that is why you are changing the name. So there are multiple factors on the basis, or you are trying to expand, or your old name is not that popular, you want to make it a trademark, or different other reasons can be there for changing the name. So one has to have a look at it this holistically. So this is the change in name clause and alteration, which is spoken about in section 13 of the Companies Act. Now, let us talk about the second important element, that is change in registered office. As we say that registered office is a very, very important element in the memorandum clause, and all because registered office is a place where all communication happens. This is the place where the address, it is kind of an address of the legal person, and it has to be fixed. It has to be very, very important. If you want to make a change, then that change has to follow a procedure. Now, when you are talking about change in a registered office, there can be multiple kinds of changes which can happen. Say, for example, there can be a change within the same city, town, or village in another premises. So, say, for example, the office is situated in South Delhi. So, one person can change from one building to another building in South Delhi itself. This is a change in premises, or definitely there will be change in address. Even there can be change in address on the same building. If floor changes, that is also a change in address. These changes are a small change and it does not affect any thing as far as memorandum is concerned. Can you tell me why it is not affecting the memorandum? Any one of you? Why this particular change is not affecting the memorandum? You can use the portal. Yes. So why do you think ROC is same? Tejas win? No, exactly not. That is not the requirement. Same ROC. Maybe in a sense you are saying, but there is a change. Why it is not said? Okay, this particular thing you will get a clarity when I tell you about the second one. Second could be a situation where one is changing from one town to another town in a same state. So this is a change which is a wherein you are changing from one place to another. Say, for example, someone from Delhi wants to, South Delhi wants to shift to North Delhi, or they want to, or in, say, for example, Haryana, if we take an example, somebody wants to move from Sonipat to Panipat. Then this is a change in the same state. Yes. So Apurva, you are right. It does not violate the MOU for a simple reason, because in the memorandum of association, only the state is mentioned. Okay. Someone has opened your mic. Please switch off your mic, please. Okay. Just a second. Who is the guy? Gaurav Sharma. Okay. Thank you. Let us now talk about this. So we are talking about one town to another town in the same state. So as I gave you an example, from one town to another town, then that is also a change, but within the same state, there is a different procedure. And for the situations where the change is from one state to another state, that requires a detailed procedure, because it completely has there are a lot of formalities which needs to be completed in this particular case. Okay. Now let me take you to the procedure when there is a change. In all these situations, there are some common things which will be required is a board resolution, right? So in all situations, whether you are changing the state, premises from one town to another town in the same state, or you are changing from one city to another town or village in another premises, except in case of one town to another town where there are ROC jurisdiction change, like there are two states which we discussed, right? There are two ROCs. One is Maharashtra and the other one is Tamil Nadu. In those particular states, if someone is moving from Bombay to Pune, then they have to follow a detailed procedure, because there are two ROCs which are involved. But if there is the same ROC within the same state, then the procedure will be less, because it is the same office where you have to make the application for changing the registered office, okay, or information to the registrar of companies about this particular change. When you are making a change within the same city, town, or village to another premises, you have to just inform. If it is a listed company, then to the stock exchange, and to the registrar of companies as per the requirement under the incorporation rules. However, when there is a change from one state to another state, then in that situation, there is a detailed procedure prescribed. So it says the alteration of the memorandum relating to the place of registered office from one state to another state shall not have effect unless it is approved by the central government. So there is a requirement of central government approval, and is the regional director on the application made in the form and the manner may be prescribed. So there is a detailed procedure for prescribed for this. So whenever such an application will be made for change in the registered office, then the central government takes time to examine this application, and they are given 60 days period to pass this order. And what central government does or the regional director does during this period? They look at the requirement of satisfying the consent of creditors, debenture holders, and other persons concerned with the company, right? Because if you are moving from one state to another state, you are moving your jurisdiction, right? So that requires a additional procedure in terms of taking consent from all their creditors, taking consent from the debenture holders, or other persons who are there in that jurisdiction. So creditors may have given the company loan because they are situated in one state. Say, for example, there is a creditor who has given a loan because the company is situated in Delhi. They know that if something happens, then we can go and get our dues, or maybe we can go and remind them about the dues. But say, for example, that particular company goes and says that no, we will have an office now in Jammu and Kashmir, Srinagar, probably, then it will be difficult for them to follow up. So that is why there is a requirement that they should all consent before the central government issues an order of change of company from one state to another state. So this is a very tedious process. Then one has to provide the declaration that the company has sufficient money or provision has been made by the company, either for the due discharge of its debts and obligation, or that adequate security has been provided for that discharge, right? So generally, this particular thing will be checked by way of an escrow. In case of debentures, if you would recollect, that is something which would be required. So this is a very, very important. There will be an alteration shruti in case if there is a change from one state to another. That will be called alteration. However, in case of same city, same town, same within the state will not require an alteration, because memorandum just mentions the state. It does not mention the address. So in the two above situations, you are only changing your address. So you have to just communicate that. But in case of if you are changing one state to another state, then you are basically changing the memorandum, because you have to change the memorandum. In memorandum, you have to mention the state in which it is belong, right? So it is very, very important change. People. Now, what is that, sir? Whether they have to pay them immediately? No, there is no need. There is a consent requirement, Tejasvi. So basically what happens here is you are trying to make a provision. So everybody should consent to it. If all creditors are consenting, debenture holders are consenting, you have a special resolution, then you can move from one state to another. It is the will of the company. And will of the company is decided by way of a resolution, right? Special resolution. And here what central government is trying to do is trying to satisfy the interest of all the creditors as well, right? So it is not just leaving it to the company to decide. It is saying basically that creditors interest, debenture holders interest, or any other person, say for example, utility service provider. So they say, for example, they have taken electricity supply from the state discom, okay, and crores of rupees are pending. Now they cannot be allowed to shift unless they pay back that particular amount, isn't it? Otherwise, how the state will recover that particular amount if they move? So all these things are taken into consideration by the central government. There is a detailed form which they have to fill so that everything is sorted before they move from one state to another state. I hope this clarifies your question, because this is the requirement of going to central government. Otherwise, you may be wondering why there is so much of a restriction on changing from one state to another state. Now, if there is a dissent, then, there are tribunal, National Company Law Tribunal, and all those processes are always there. Now, coming to the further point, it says where an alteration of memorandum results in transfer of the registered office of a company from one state to another, a certified copy of the order of central government, which you saw in subclause 5 above, approving the alteration shall be filed by the company with the registrar of each of these states within such time as may be prescribed, who shall register the same, and registrar of the state where registered office is being shifted to shall issue a fresh certificate of incorporation. So say, for example, company is moving from Delhi to Sonipat, then in that case, they have to file this particular this approval by central government in Delhi as well as Chandigarh, and the Delhi person will, cancel the incorporation, and the other person will issue the incorporation, a fresh incorporation. And by this way, the company gets seeded from Delhi to the Sonipat. This is how this situation will work. So this is the second clause. Okay. So this is a very important point. Okay. So, Mr. Makwana, the discharge of all debts and obligations basically means that they are in a situation to discharge. Say, for example, they have a liability of 50 crores. Then they should have that much of amount in their bank, or they must have that much of an asset to satisfy that particular debt and obligations. This is what it means. Okay. So if they want to change from one state to another state, they need to meet these obligations. Okay, I hope this answers the query. Let us move further. Now, there is a requirement if there is a change whichever happens in relation to the alteration of memorandum, notice of this has to be given to the registrar. Okay, so wherever there will be alteration of share capital, a notice to the registrar has to be given. There is a requirement of a special resolution which has to be passed by the company. And then there is also a requirement of approval of central government. If there is a name of, if there is a requirement of change in name that we have already discussed. Whenever there is a company which issues a prospectus, so a company which has raised money from public through prospectus, and still there is a amount which is left out of that particular money which they raised from the prospectus, then they cannot, change the objects of the company. So here now we are talking about change in objects of a company. Without a special resolution. So if, say, for example, a company has done the the company has raised a capital. Say, for example, they raised 5,000 crore rupees for a specific project, X project. Okay. And now they want to change the object of a company. So here there is a requirement that this company, when they want to change the object of the company, they have to pass a special resolution of the company. Without that, they cannot make the change. Further, they have to go ahead with publication of this particular resolution in the newspapers. So they have to make a publicity of this newspaper, because in case of companies which are public companies, then those companies have to be extra cautious. There are some additional extra requirements which requires them that whenever there is a change of objects of a company which has raised capital through prospectus and the money is still remaining, then in that situation they have to make a resolution, has to be published in the newspaper, one English and one in vernacular language, which is circulated generally near the registered office of the company where they are situated. And they have to also place this resolution on the website of the company, indicating therein the justification of change, why that particular change in the objects is being made. That justification has to be placed before. This is for a simple reason that you need to keep your, there's a basic principle of corporate governance, transparency. So objective here is that all the existing investors who have invested in your company, if you are making the change in the objects, they should be aware about that. You cannot change the objects midway, because when you raise the capital, the company, the people who invested in your company, invested for certain objectives. They had something in their mind. And now you want to change that particular object. Probably their investment will take a hit, or they may not be happy with your new objectives. Then in that particular situation, they should be given a window to withdraw their money or take appropriate steps. And that is why there is a requirement of notifying everyone, because many a times you may have a resolution put on the website, but probably nobody has gone through the website. That is why there is a requirement now to publish it in newspaper. Then dissenting shareholders. Somebody asked this question on dissenting shareholders. So here the dissenting shareholders shall be given an opportunity to exit by the promoters, and the shareholders having control in accordance with regulations to be specified by the Securities and Exchange Board of India. This is only in cases where there is a change in object clause, not in the name clause or not in the other clauses. Okay. There, if if they are not happy, then they can just exit the company if with that particular change, the remaining one which do not agree to the change. Here, I would like to also, mention, and though it is not part of your syllabus, you should read this section 27, which talks about variation in terms of contract or objects in a prospectus. This is quite related provision of subclause 8, which you have seen just now. It is a related provision. So you should definitely read this provision, which mandates the requirement, because previously what used to happen that people used to raise money on X count, and they will utilize that money for Y count, Z count, and the investors felt defrauded. Okay. There is a case also to this effect. If you would recollect the Iridium Technologies case, Iridium versus Motorola case. So this is a case in which they issued a prospectus on some grounds, and later on they invested the money on another grounds. And there was a case filed of a fraud against the directors of the company in Pune. If I am not wrong, the case was filed in Pune court. There was a summons was issued, and this was challenged before the High Court, saying that this is not right. This was not on the point of Section 27, but on the point that whether companies can be prosecuted for criminal offenses, because it was 420 then, now it is 318 Bharatiya Nyaya Sanhita. So the court said that companies cannot be High Court said the companies cannot be prosecuted for mens rea offenses, that is the guilty mind offenses, crimes, because they cannot have a mind. But the Supreme Court ruled otherwise. It said that yes, there can be mind of a company can be derived from the board, because they decide on behalf of the company. And that is what is the, will of the company has to be traced from the board. Quite an interesting decision. If you people are interested in reading something extra, then you can read this case, Iridium versus Motorola. It is a very, very interesting case on corporate criminal liability. Okay. Though not part of this portion, but still, as my habit, giving you some additional information. So just keep that particular information. If you are interested, you can read about it. Now let me move further and talk about the alteration of memorandum we are discussing. Change in object clause. And as I said, the change in object clause, there are two methods. One, where a company has not issued a prospectus, and by a company which has issued a prospectus. These are two situations in which change in object clause has got different methods. So wherever there is a alteration of memorandum, the registrar shall register any alteration of memorandum with respect to objects of a company, and they have to certify this registration within a period of 30 days and the date of filing of special resolution. This is what is the requirement. So every change or alteration in the memorandum has to file with the registrar. Registrar will certify those particular changes. No alteration made under this section, that is section number 13, shall have an effect until it has been registered in accordance with the provisions of this section. So there is a very, very clear requirement of this. Yeah. Yes, Pranav, prospectus and IPO. IPO is initial public offering. Prospectus is basically a statutory requirement under the Companies Act. So you can say it is quite similar because IPO issue is also about transparency, giving information. Prospectus as a document is also. So for an IPO, prospectus has to be issued. This is what is in a nutshell. IPO is a whole process. Prospectus is a document which needs to be issued for IPO, that is initial public offering. Now, any alteration of memorandum in the case of a company limited by guarantee and not having a share capital, purporting to give any person a right to participate in the divisible profits. You would recollect the definition of company limited by guarantee, right? So the company limited by guarantee cannot give profit, or they cannot share profits. Then this will not be right. So you cannot have an amendment in the memorandum wherein you permit the persons to have divisible profits of a company in case of a company limited by guarantee not having a share capital. If it is having a share capital, then definitely you can have some provision. But in case of the company limited by guarantee not having a share capital, you cannot give any divisible profits to the members. If you do that, then that change will be a void. Void means you cannot make it legal later on by ratification as well. So this is the overall requirement under the change of memorandum of association. Now I think at this particular stage I should open your questions. So now you can raise your hand. I will permit you to ask your questions. Okay, so we will have couple of questions from you people. Yes, Hardik has a question. You can ask a question. I have given you permission, Hardik. Go ahead.
Uh, Good evening, sir.
Good evening.
Sir,
Yes.
sir, in the last point, it is written any alteration of the memorandum in case of company limited by guarantee and not having share capital purporting to any person right to participate in the divisible profits otherwise than as a member. So, sir, member
Yes.
can participate.
Yeah, yeah.
So, sir, this means that member can participate.
Yes, that is what it means. That is what it is giving the clarification, right?
Other,
Purporting to give any person a right to participate in the divisible profits of the company otherwise than as a member. So when you say otherwise than as a member, then you have to change the nature of it, no? So you have to, because any company which is being made, that is made for some profit, right? In case of guarantee, company limited by guarantee, they can have profits, but that is only to the respect of the guarantee which has been given by the person concerned, right? If they are
so, sir,
having share capital, then that particular ratio is very, very clear. But if they are not having the share capital, then other than people who are not members cannot be given this rights. That is what it is saying.
sir, that was my doubt that outsiders are not
Yes.
allowed, only members are allowed to the extent of.
Yes.
Okay,
Correct.
sir.
Correct. Correct.
Thank you, sir.
Yes. Anyone else? Rashmi. Okay. I will ask Rashmi now. Rashmi, you can ask the question. I haven't I have asked you to. Yes. You can ask the question. Yes. Go ahead.
I doubt regarding in case of alteration of name of the company.
Can you go ahead a bit louder, Rashmi? I'm not able to hear you.
Yes, sir, I have doubt regarding any change in the name of the company is the required a special resolution. And
Yeah, there is
the
a requirement of a special resolution. Yes.
but in case of a change public to private, there is no requirement of a special regulation.
No, in case of a public and private, also there is a requirement of a special resolution. There has to be. There is no requirement of a permission from the central government in that case. Are you getting the point? There is a requirement whenever there is a change in name, you have to take permission from the central government, except in case where you are changing from public to private.
Okay, sir.
Okay. Yes, Bhavna, go ahead.
Good evening, sir.
Yes, Bhavna, go ahead.
Sir, what is the procedure while uh, uh, in the case of situation clause there is same town and city.
Yeah, same town and city, there is no, the procedure will be same. You know, there has to be a resolution which requires to be passed. But in those particular situation, you don't have to take permission from the central government. As we saw, regional director, the permission will not go. Right? In registered office, you are asking, no?
Okay, sir. Sir, one
Yeah.
more doubt.
Yes.
Sir, in case of a change in state, change in register office from one state to another, then in such a case, preference shareholder consent is also required.
No, so everybody's consent will be required there because we are asking debenture holder, we are asking the creditors. So definitely all stakeholders.
Sir, what is board resolution?
Yeah.
Sir, what is board resolution?
Board resolution is basically resolution by the board of directors. Okay. There are two
Okay,
kinds of
sir.
resolution. One resolution is coming from all the shareholders in the AGM. The other resolution is by the board. Any decision which is taken in the company is started by board resolution first. So the board has to first, take up that agenda and decide, okay, fine, we have taken care of. And then it goes to the general meeting in case of special resolution wherever it is required.
Okay, sir. Sir, in this 11th point, if a company limited by guarantee and having a share capital, in such a case, other than member are allowed to take part in the profit?
No, not other than the member, only members. Okay.
Sir, I have a doubt if there is a having share capital.
Okay.
In such a
So
case,
when they have a share capital, then obviously the share capital clause will put that particular thing. So say for example, you are saying a situation where and not having a share capital mentioned here. If it is having a share capital, then obviously they will have. Okay, this I got your question. Okay, let me get back to you on this.
okay,
Next
sir.
question. Anybody else? Sai Charan. Yes, Sai Charan. Go ahead.
Sir, that means in subsection 11, member means in case of company limited by guarantee, if he is not a member, he is not allowed to the divisible profits of the company. Is that what that provision says?
Right.
Then who are all members? Is that they mentioned in their how
No,
can
come again.
if I hold a shares in case of a company limited by shares, if I am holding a share certificate, I will be a member. What
Yes.
in case of company limited by guarantee? Who are all can be mentioned as an members?
Members can be the people who are subscribing to that particular company and they are giving that guarantee, right?
Guarantee.
So yes.
Okay, fine, sir. And then in case of address in change in location, only why emphasis was given on the state information only, sir. Only state is mentioned is that involved for a company
Yes,
to
because if
represent.
you change from one state to another state, there is a requirement, there is a change in jurisdiction, no? So when you are changing the jurisdiction from one state to another state, everything gets changed. Because if you are within the state, your high court is having a jurisdiction, your courts are having a jurisdiction over the company. But once you move from one state to another state, then dynamics completely changes. So you
Sir,
cannot
but law
have
doesn't
control
change.
over that particular company, right? So that is why there are additional requirement wherein central government has to satisfy that all dues which are there on that company can be payable by the company. Okay, and every stakeholder gives permission to that particular change.
I am okay with that, sir. But within the state, why that emphasis was not given on a specific address, sir? Because as a shareholder, I'm investing in a stock market, and if I'm looking at a MOA, and I found only in a state, how could I find where was the primary location of an company, uh, uh, sir, or else
No,
an
you can
operation?
because it will be under the jurisdiction of the same ROC, same people. No?
So that means for a one state, one register of company, right? Is that
Yes.
implies that? Thank you, sir.
Yeah, we saw that 25 register of companies are there. We have already seen that.
Okay, fine, sir. And national company law tribunal jurisdiction also will be the same for one state, one national company.
No, on that case, it is not like that. So I think there are 12 or 15. I don't recollect the exact number of National Company Law Tribunal.
Okay, fine, sir. Thank you.
Okay. National Company Law Tribunal is different. Okay. Yes, Archana, go ahead.
Good evening, sir.
Yes.
When you were explaining about special resolution, I was not clear about the what do you mean by special resolution, as my net was disconnected during that time. Can you please explain me?
Whenever we say special resolution is different than ordinary resolution. Okay. These
Okay.
two terms are defined in Companies Act. Read that. It will give you clarity. But for your information, ordinary resolution, when we are talking about ordinary resolution, talks about majority. Okay. Special
sir.
resolution, it talks about more than majority. Depending on the situation, it can be 70 to 90% can be called as a special resolution. Different circumstances require different kind of voting. Like, for example, if you see section 242 of the Companies Act, there is a provision of a resolution of 90% of the people should be there to succeed that particular scheme. You know, so squeeze out provision, 90% people should agree. That is a special resolution. Special resolution generally is 2/3 of the people.
Majority.
Yes, majority, not majority. Majority comes 51%.
Okay, sir.
It is more than majority. Okay.
Okay, sir. Thank you.
Yes. So that is what is the special resolution. Okay. I think now I have answered all your queries. Now we will move ahead with our next slide. That is basically talking about the object, the articles of association. Let me see whether there is a. Okay. I have answered all queries. Let me move further and talk about alteration of articles. Now we have seen already the articles of association before, and articles of association is kind of bylaws, for effective functioning of the company. It provides for detailed rules. It provides for detailed, procedure for different dimensions and aspects of working of the company, right? We have also seen various clauses under the articles of association, like, for example, share capital, how lien will be given. All these provisions we have seen in our previous class. Now, whenever you have to make an alteration to the articles, you can make that. However, the provisions, you have to follow the provisions given under section 14 of the Act. And it says specifically that the subject to the provisions of the Act and conditions contained in the memorandum, if there is a special resolution, you can alter your article, including any alterations having the effect of. So even you can alter the article which can make your company from private to public and public to private. Okay, these two changes also. You recollect the articles which differentiates between public and private? Yes, you can use the portal to answer this query. The differentiation between public and private because of articles of association. Yes. I hope you recollect that. You recollect this particular slide we have discussed in our previous session. Okay, difference between public and a private company. You can see there is a restriction which is mentioned in case of private company in the articles of association. And there are basically, important restrictions. One is articles restrict the right to transfer its shares. This is a requirement in case of a private company. And also it prohibits any invitation to the public to subscribe for any securities of the company. If the articles mentions these two things, then it will be considered as a private company. So in case of private company, there is a requirement of restriction in the articles about transferability of shares. So this is the important thing which has been mentioned here. Now, here there is a proviso which says, provided that where a company being a private company alters its article in such a manner that they no longer include the restrictions and limitations which are required to be included in the articles of private company under this Act, the company shall from that particular date cease to be a private company. This is the difference So alteration of articles can be done. Generally, alteration of articles cannot go beyond the memorandum of association. So if you have some powers in the memorandum of association, or you have some restriction in the memorandum of association, you cannot make those particular changes by way of articles of association. Articles of association shall always conform to the memorandum of association. Now, in case of alteration, wherein you are making an alteration where public company is converted into a private company, it will not be valid unless it is approved by an order of the central government. So private to public, you don't require this approval, but in case of public to private, there is a requirement of taking permission from the central government. You know why the reason why you require this permission? Yes, any one of you? What do you think? Why there is a permission
Public to
required
private
from
rights.
central government in case of public to private?
That means in public, there was an interest of shareholders, right, sir? Now it was
Yes, large number of shareholders are there and everybody's interest needs to be taken care of. So there can be thousands of shareholders and you need to take care of everybody's interest, and that is why central government permission is required. As you saw, there is a requirement of, in case of registered office, central government permission is required. In case of change in name, central government permission is required. Those major milestones or changes in case of company's constitutional documents, there is a requirement of permission from the central government. Objective here is to provide the fairness, to ensure that the company is not doing any hanky-panky business. That is what is the job of the regional directors, ROC, and they evaluate this from the perspective of fairness, from the perspective of equity, so that they can have a look at it holistically. So this is the idea. Further, it will not be approved if there is an application pending before the tribunal as on date of commencement of the Companies Amendment Act 2019. So this was a change which has been made because of the 2019 Act. There was some change which was brought, wherein the power of a tribunal has been given to the central government. Okay. So previously this power used to be alteration of articles, permission power used to be there with the tribunal. Now in the ease of doing business dimension, they have transferred this particular power to regional director. A number of powers, if you will look at the Companies Act, has moved from the tribunal to the central government for making it more easier for the companies to approach the central government and get the work done. So it further says every alteration of articles under this section and a copy of the order of the central government approving the alteration as per subsection 1 shall be filed with the registrar. You have to also take a printed copy of the altered articles within the period of 15 days in such manner as may be prescribed to the registrar, and it has to be filed. Alteration will only take effect once it is registered with the registrar, and it will be valid and it will have same effect as if it was the original articles. So this is the overall provision relating to the change of articles of association. This we have already seen. I also wanted to talk about entrenchment clause. So we have seen this particular clause. If you recollect, in our previous sessions, we discussed about entrenchment clause. Entrenchment clause is basically a provision in a legal document that makes certain amendments either more difficult or impossible to implement without meeting some stringent conditions. Okay. In corporate governance, these are actually used to protect certain rights, powers, or they don't want an easy alteration. So now, under the Companies Act 2013, this entrenchment clause is permissible. If you see, this is an example. For example, there is a clause 10 in an articles of association which says protection of shareholders' voting rights. And it clearly says that clause 10 shall not be amended, repealed, or replaced unless such amendment, repeal, or replacement is approved by a special resolution, and there is a specific percentage mentioned, 75% of the shareholders entitled to vote at a general meeting. And it is further saying approval of 90% of Class A shareholders. The written consent of at least 90% of all Class A shareholders, irrespective of the number of votes cast at the general meeting, is an additional requirement. So this basically makes the change in clause 10 bit difficult. So it says no amendment to this clause shall be valid unless these conditions are met, and any attempt to alter this clause without fulfilling these conditions shall be null and void. So these kinds of clauses are referred to as entrenchment clause. So you cannot change the articles of association having an entrenchment clause. You have to meet the condition mentioned in the entrenchment clause to make the change in that particular articles. So I hope this is clear to you now on entrenchment clause, because I think there were some queries in our previous session. Then we are talking about alteration of memorandum of articles, which has to be noted in every copy of the company, right? I think now we are at 7:07. Let us take a small break. How many minutes break you want? 10 minutes is fine for you people. 10 minutes. Yes. It is 2777. Yeah. Or if you have any questions till this point, I can answer that. Mawsam has a question. We'll take a break at 7:15, okay? For 15 minutes till 7:30. You can ask a question, Mawsam. I have given you permission. Go ahead.
Sir, my question about the alteration or articles.
Yes,
It's converted like, sir,
it
when
is.
when public to private account, it's converting.
Yeah, it is kind of a conversion only. You see, whenever there will be a change in articles, why do you change? For multiple purposes. One of the change is relating to conversion.
Yeah, sir. That last
Yes.
question, that 11 point is now there mentioned shall be void. The meaning of shall be void, sir, what? That
Shall be void. That means anything where it is mentioned shall be void means it is not existent. So if say, for example, when we say that any agreement entered against the public policy shall be void, means that agreement does not have any legal standing. That is
it's
called
like
shall be void.
ignorance.
No. Agreement are of two kinds. One is void, the other can be voidable, right?
Okay,
So
sir.
void agreements cannot be ratified subsequently and made legal. Void agreements is illegal from the beginning. It has no
Yeah.
legal value, right? You
It's
cannot bring even the question on that particular contract or article before the court because it is void.
yeah.
If it is voidable, then there can be a question if you gave the consent or not gave the consent, that kind of a thing can happen. Okay,
Yeah, now I understand, sir. Thank you so much,
right?
sir, for clarification.
Okay, Bhavna, go ahead.
Sir, I have a doubt regarding the conversion of public to private company. In such a
Yes,
case, need a approval of central government.
yeah,
But sir, earlier you tell us while adding a private word with the name of the
yes,
company, we have no need to the approval of central government.
yes,
Sir, what
yes,
is
you are right.
the
So
sir?
when you are
What
saying, when you are adding the word private, then there is a not in the name clause. For the name clause, you don't require the permission. But when you are changing a company from public to private, definitely there has to be a permission, right?
sir?
At that point in time, we were discussing about the name clause. See, these are different permissions. Different clauses give different requirements of permissions from central government. You are understanding?
Okay, sir. Clear.
Yes. Yeah.
Sir, one more doubt.
Yes.
सर वो डाउट खो गया
कोई बात नहीं, आप जब आएगा तब पूछ लीजिएगा, ठीक है? रश्मि, आप नोट कर लिया करें जो क्वेश्चंस है ना आपके, यू जस्ट नोट इट डाउन.
Yes,
Go ahead,
sir.
Rashmi.
Yes, sir. I have doubt regarding entrenchment clause, clause 10, protection of shareholder voting right. This required to pass a special resolution majority of at least 75%. Then what is clause A shareholder 90% approval means?
Okay, see, this is just an example. So this may not be, related to the provision. This is just to explain you the entrenchment clause. I have created this example. Okay. So this is not as per any section as such, but there are provisions where 90%, voting, 90% is required. Like say, for example, if you are going for mergers and amalgamation and you want to squeeze out the minority, there 90% people should be there with you with this scheme, then only you can go ahead with that scheme.
Sir, ये class A shareholder means?
No, come again. Class A shareholders. So
Yes,
there are
sir.
different classes of shareholders, na? Preferential shareholders, ordinary shareholders. This is talking about that. So class A shareholders are likely having voting rights. This is what my understanding was. Okay, Hardik, go ahead.
Sir, I need a small clarification, sir. Sir, if
Yes.
we change from public company to private company, we need a approval from central government. But sir, if we
Yes.
change from private company to public company, then no need of approval, no?
No, private company to public company. Anyways, there are a number of approvals which you have to take. So there is no special approval required.
Okay, sir. Only for like
Yeah, because
adding
see,
of
when you are going ahead with issuance of prospectus or if you are going for listing, all those things will require a lot of approvals already. So there is no need for an approval.
okay, sir. Thank you, sir.
Yes. Yeah.
Sir, this
Okay,
is Sai
guys.
Charan.
I think I have answered all your question. Yes, Sai
Sir,
Charan, you want to ask some question? Go ahead.
yes, sir. If this entrenchment class, this makes provisions more tougher, right, sir?
Hmm.
Then who's entitled to take care whether that provisions are taken care of or followed? Uh,
No, obviously, the people who are part of it, members, they have the duty to follow the articles which is mentioned. Otherwise, their decision will become illegal, no?
is that a board of directors or that a
Yes,
company
board of
secretary?
directors and even the members in an AGM, they have to follow. Subsequently, if it is noticed, then that decision will become illegal. So nobody wants to, keep an illegal decision.
Because why I'm asking this is, but this can be used to exploit the shareholders' rights. Because I have made an entrenchment clause which brings the confidence of shareholders in my company, whether I can dilute it, right? So that's why I'm asking that.
No, but when you are making the entrenchment clause, this generally happens when you are framing the articles in the beginning. See why entrenchment clause has been provided? Because entrenchment clause has been provided in case of private company because to protect the private stakeholders. That is the objective. The people who
Sure.
have formed the company or people initially formed the company, they put the entrenchment clause so that nobody can in the future, take away their rights by making an easy change. This is what is the required.
Sir,
Okay.
sir, one additional point with Sai Charan I want to ask.
Yeah.
Entrenchment clause are usually added on the basis of memorandum. They cannot go beyond memorandum, no?
No, definitely anything cannot go beyond memorandum. Articles of
So,
association.
sir,
Sorry, चलेगा.
memorandum and articles of association. Okay. So let us look at some of the situations and cases which has come up in these alteration of articles and memorandum of association. As noted before, any alteration of the articles cannot go beyond the memorandum of association, and nothing can go beyond the provisions of the Act. So everything has to conform talk about some of these cases. One of the important cases which is there on this dimension of alteration is basically dealing with a situation where the question arose that can a company replace its articles, or what should form the part of the resolution when a resolution is passed by the special resolution is passed, whether the articles should be part of the special resolution. So the court held that you cannot replace your articles. You cannot change your articles. It is only the regulations contained in that particular articles which can be changed. So this is a dimension which has been dealt with by the court in that situation. Okay. If you have a look at this dimension, this case was basically before the 1956 Act. This clarification came before the central government, and the central government clarified this situation that there is no need for keeping the whole article. So never the whole articles of association never changes. It is the clauses of that articles of association which changes, even if you are changing all the clauses. Then also the basically frame of that article which has been approved before remains the same. This is what is the interpretation of this point. One important factor is that all these alterations needs to be bona fide and for the benefit of the company. So whenever there will be a resolution which will be passed, the articles changes, the resolution shall mention that why you are making the change, and you have to also mention that this is for the bona fide requirement or benefit of the company. If it is proved that it is not bona fide for the company, or it is with an ulterior motive, then in that situation it will be considered as not legal. Okay, generally say, for example, if it is violating any of the norms, or you are taking a circuitous route to do a illegal activity by altering the articles, will not be correct. Like, for example, a breach of contract cannot be permitted by changing your articles. So just because the articles puts you in an inconvenient situation, you make a change and do a breach of contract will not be permitted. Like, for example, in Matrubhumi printing case, it was held that the company will always be liable for damages in case alteration of article results in breach of contract which company has entered into with a person. So there is something which is called legitimate expectation. So when you had an article before, on the basis of that article, if somebody takes an action and tomorrow you change the article for the detriment of that person, the person can always bring up action for damages, right? A company cannot alter its articles to break a contract, right? So if that is done, then that will be consequences have to be faced by the company. Similarly, you cannot amend an article to expel a certain board of director member in certain circumstances. And this exactly happened in case of K. Leela Kumar versus Government of India. It is a 2002 matter wherein a public limited company amended its articles of association by including a clause by a special resolution passed at the extraordinary general meeting of the company, by which they empowered the board of directors of a company to expel a member in a case where the board is of prima facie view that activities or conduct of the member is detrimental to the interest of the company, or that by reason of his continuance as a member, it would be prejudicial to the future of the company. This was done not when that member was appointed, but later on, subsequently, just to remove that particular member, they included this clause, and then a resolution was passed saying that this member's continuance in the company will be prejudicial to the company. Here, the Ministry of Corporate Affairs was of the view that amendment of articles of association of a company providing for expulsion of a member by management is opposed to the fundamental principles of company's jurisprudence and would be considered as ultra vires. This is something which was dealt with in this particular case. So these are some of the examples which basically shows that while the alteration of memorandum and articles of association has been provided under the Companies Act, these provisions have to be legitimately utilized. You cannot, do an illegal activity or activity which is against public policy, or you want to take a circuitous route by way of these changes to violate some provision of the act or memorandum. That cannot be done by these provisions. So this is what we end bona fide. Bona fide basically means honest. Bona fide means that. I hope I have answered all your queries by this particular time. I will also open up the question and answer session subsequently. So there you can ask all your questions. Let me complete the presentation. Okay. Now let us move ahead. If you want to ask some questions on your portal, that is open. So you can ask any questions at the portal at any time you feel like. Okay. Now let us move ahead and talk about the alteration of memorandum of articles to be noted in every copy. This is section 15 of the Companies Act, and it says that whatever copies of memorandum and articles of association has been published or kept, in all those copies, the changes have to be noted. So say, for example, the memorandum of and articles of association were made at that particular point in 3 copies or 5 copies in original, because that is what is signed. Original copy is kept in the company, and then there is in ROC. If company has 3 offices, and at each office they have kept a copy, then all these particular copies, in every copy, the alteration has to be reflected. This is what this provision says. Let us look at the provision. It says, every alteration made in memorandum or articles of a company shall be noted in every copy of the memorandum or articles as the case may be. So as many copies of memorandum and articles are there for public purposes or public view, all those particular places it will be changed. And that is why you will see in memorandum of association, all changes which are made subsequently are also reflected. Either it is the older certificate of incorporation or older documents, everything is mentioned. In fact, in some of the memorandum of association, you will even find a tribunal's order or court's order also annexed to that, because it makes some changes to the document. Here, I would like to put across a very interesting fact is about amalgamations. So many a times during amalgamation, memorandum will change, articles will change, because pursuant to the scheme of amalgamation, pursuant to the scheme of arrangement, in those situations, these procedures need not be followed, because the tribunal takes care of the whole scheme, and that is considered as an automatic change, and that is filed before the ROC. That itself is a requirement of change in memorandum and articles of association. There is a different route to make a change of articles of association and memorandum of association in case of mergers and amalgamation. Probably you will have this section, this provision next. Whenever you will be taught mergers and amalgamation, you will note this particular point. Now, if a company makes any default in complying with this provision, there is a penalty which is mentioned there. All officers who are in default are required to pay a penalty of 1,000 rupees for every copy of the memorandum or articles issued without such alteration. So say, for example, today there is a change. Now, if you make any issue a memorandum or an article without that particular change, there will be a fine of rupees 1,000 for every copy. Section 17. Section 17 talks about copies of memorandum, articles, etc., which requires to be given to the members. So this provision basically enables the members to ask for memorandum of association and articles of association from the company itself. It is the duty of the company. In every company also there are share and transfer agent, or there is a registrar to the company. basically who takes care of all transfer of shares or a list of members he maintains. So that particular job is there with that person, and it is a requirement to give a copy of memorandum and articles or any other public documents which shall be accessible to the members have to be given a copy of. So if you see here, a company shall, on being so requested by a member, send to him within 7 days of the request and subject to payment. So there can be also a payment which can be prescribed. Generally, these are mentioned in the articles or maybe by way of a notification by the company. Such fees as may be prescribed, a copy of the following documents. These are the documents, the memorandum, the articles, and every agreement and every resolution referred to in section 117. This basically deals with the resolutions which are required to be filed. There are certain agreements which requires to be filed, like say, for example, share purchase agreement, SPAs. There are certain SPAs which needs to be filed. There are certain resolutions. Some special resolutions need to be filed with ROC. Anything which is required to be filed under section 117 subclause 1 has a copy, if someone wants, has to be provided to them within 7 days. Okay. If a company makes a default in this provision and they do not provide for, then there is a penalty of 1,000 rupees for each day during such default continues, up to 1 lakh rupees, whichever is less, that is the penalty amount. These provisions basically entitle the members to get certain documents. And you may think that why there is a requirement of this provision, everything is publicly available. But many a times getting documents from companies becomes very difficult. They are secretive. They don't want to share the documents or certain in certain situations. So in those situations, to enable transparency, these provisions are mentioned. So you have seen in section 15, all alteration of memorandum and articles required to be kept in all copies. Copies of memorandum and articles requires or any other document which is mentioned in sections 117 has to be shared with the members when they ask for. Company can ask for a nominal payment or requirement of a payment which they can mention as per the resolution which they have passed in the board. But the availability of the document has to be brought before the people. Now there is a section 18 which talks about conversion of a company. So we have discussed this briefly in our articles of association, because you saw why we discussed there, because articles of association is an important document to find out that whether a company is a private or a public company, right? So if a company is private company, there are more restrictions in terms of transferability of shares. That is a requirement under the Companies Act. Now, what is the conversion of a company? Here it is said a company of any class registered under this act may convert itself as a company of other class under this act by alteration of memorandum and articles of the company in accordance with the provisions of this chapter. Now, there are certain companies which cannot convert itself, right? So we have already seen one-person company cannot convert itself into charitable company. So this is a restriction. Now, where the conversion is required to be done under this section, registrar shall satisfy himself that the provisions of these chapters have been met. Okay. And then they will close the previous registration of the company after registering the document and then issue a fresh certificate of incorporation as if as they issued in the first registration. So the whole process changes. There is a new certificate of incorporation. Whenever there is a conversion of a company, a new certificate is issued. Either it is from private to public or public to private. In case of one-person company converting into private, all these particular processes, one-person company, by the way, is a private company only. But still, if they are adding more members into one-person company and making it a proper private company, then in that situation, they have to make this application and these changes have to be brought. The registration of a company in this section, however, will not affect any debts, liabilities, obligations, or contracts which are incurred or entered into by or on behalf of the company before the conversion, right? So it cannot happen that now you have converted into a public company, so your private company debts are, discharged. That will not happen, right? So these things will continue as if the company was already in existence before. So this generally what happens is these provisions are taken care of by the central government when you are making a conversion application. You have to satisfy the central government. Okay, fine. We are meeting all these requirements and hence convert us. And that is why you saw the requirement of public company converted into private company. There is a requirement which has to be fulfilled. Now, this is just an example of conversion of one of the companies. You may be aware about this company. Everybody is aware about this company. So you can see its CIN number, and CIN number shows that it is a, what does the CIN number shows? Yes. Can you people use your portal to answer this? What does the CIN number of this company shows?
Type of company.
Yes, it is a public limited company. It is listed in Delhi. Very good. What else it is showing? Yeah. Right. So this is basically after the public offer. Before this company was like this. So this was the CIN number. So it was an unlisted company and it was a private company, right? Registered in Delhi. However, its registration number is same as you would note, 198141, right? So this is a change which has happened. So from private limited, private has gone and it has become Zomato limited. And this is the change how it happens. As you can see from here, this is the requirement. Hold on your questions. Some participants have raised your hands. Just note it down your questions. I will be answering that towards the end. Okay. Now, this particular thing reflects that how the change happens from private to public. Now, there is another provision which talks about subsidiary company not to hold shares in its holding company. So there is a restriction, some restriction on the subsidiary companies to not hold shares of its holding company. And this restriction goes like this, and it says, no person, no company shall either by itself or through its nominees hold any shares in its holding company, and no holding company shall allot or transfer its shares to any of its subsidiary company, and any such allotment or transfer of shares of a company to its subsidiary company shall be void. We have already understood what is void, right? Provided that nothing in this subsection shall apply to case where the subsidiary company holds such shares as legal representative of a deceased member of the holding company. So if somebody from the holding company has died and subsidiary company held that particular share only as a representative, that will not be considered in this calculation. Where the subsidiary company holds such shares as a trustee, or where the subsidiary company is a shareholder even before it became a subsidiary company of the holding company. So there is a restriction that subsidiary company should not have shares of the holding company, right? Because it makes challenges in terms of calculations. Because ideally speaking, holding companies should have shares of subsidiary companies, not subsidiary companies having shares of holding companies, right? This is how the relationship is between the subsidiary and a holding company. Provided further that subsidiary company, as referred to above, shall have a right to vote at a meeting of the holding company. This is with reference to the shares which have been held in representative capacity or trustee capacity, which you are seeing in clause A, B, and C. Now, the reference in this section to the shares of a holding company, which is a company limited by guarantee, or unlimited company not having a share capital, shall be construed as a reference to its members. So in situations of unlimited company and company limited by guarantee, whenever you are talking about reference to shares, you are talking about interest of the members. Here, I would like to pick up your question. One of you had a query with reference to the subclause 11 of section 13, right? Memorandum of Association, which basically said an alteration of memorandum in case of a company limited by guarantee and not having a share capital, purporting to give any person a right to participate in the divisible profits of a company otherwise than as a member shall be void. This is what the provision says. So here it is referring to a situation that in case of a company which is not having a share capital and if the person is also not a member, then you cannot give any profits to anyone or you cannot have a divisible profits kind of a situation. Whereas in case of a company limited by guarantee having a share capital will entail that these you are carrying the shares, so proportionately you will have the right to the profits of the company, right? So share you are having dual kind of a situation where you are also giving the guarantee, also you are having a share capital of that particular guarantee company. So that situation will not arise. I hope this clarifies subclause 1 to you people. If still it is not clarified, we can deal with it towards the end of the presentation. Let us move further and talk about an important provision, that is section 20, which talks about service of documents. And it is very important provision because if you will see many of the situations, not a proper service actually raises the question of principle of natural justice. So there has to be a provision where your documents gets serviced or any notice has to be sent, it goes to the appropriate person. This needs to be very, very clearly established, and that is why section 20 talks about service of documents. It says a document may be served on a company or an officer thereof by sending it to the company or the officer at the registered office of the company. Okay. By registered post or by speed post or by courier service or by leaving it at registered office or by means of such electronic or other mode as may be prescribed. So if you will see this provision, the regulations or rules are more pragmatic and they are including the electronic mode as well. Provided that where securities are held with a depository. What is a depository? Depository, I hope you people know. So nowadays shares are held in electronic form. So these electronic form shares are held with the depository. There are two depositories, CDSL and NSDL. These are the two depositories with which the company's shares are held. They hold this particular share as a registered owner. Beneficial owner is the person for whom they hold these shares, right? Say, for example, I have a demat account and I hold X number of shares of Y company. Then my registered owner is who? My, demat bank account. Let's say, for example, it is ICAI Securities. So that is the registered owner. Why you make them the registered owner? Because as per law, they are authorized to make the transfers. If you don't make them registered owners, as per law, they will not be, as per Transfer of Property Act, they will not be able to transfer the shares. That is why you have to make them the registered owner. However, they are acting on your behalf. So you become the beneficial owner. So this is how this deals with. So it is saying if your shares are held with a depository, the records of the beneficial owners may be served by such depository on the company by means of electronic or other mode. Now it further says the same as provided in this act or rules made thereunder for filing of documents with the registrar in electronic mode. A document may be served on registrar or any member by sending it to him by post or registered post or speed post or by courier or delivering at his office address or by such other electronic means or mode as may be prescribed. So if you see the rules, particularly 35, which talks about service of documents, mentions a long list of methods by which you can transfer the you can make a service. Here, for the purposes of this section, courier means any person or agency which delivers the document and provides proof of its delivery, that is referred to as courier, right? Now, there is a provision which says that a member may request for delivery of any document through a particular mode for which he has to pay such fees as may be determined by the company in its annual general meeting. So, service of documents, there may be a procedure which company may have laid down. There may be a fee requirement which the company may have been, laid down. Generally, for registered post, I don't think there would be any charge. But if you are making further changes, like for example, you want to do courier or speed post, then in those situations, there will be a requirement of some additional fee. If you opt for nowadays, I think because of ESG requirements, number of companies are preferring to ask their shareholders that would you accept to take your annual report in soft copy. So generally they will send you, they will take your consent, and after that they will send you their annual report in soft copy on email or notices of meetings on email. So you as a shareholder can decide which mode of service you will accept. So this section talks about service to the company. It talks about service to the registrar of companies, as well as it talks about service how has to be made to the members of the company. And this is an important provision because as I told you, if the document does not, say for example, company may say that yes, I have issued the notice for AGM, but whether it has reached or not, where from you get that particular data. So you have to have the speed post receipt, registered post receipt, that yes, it was posted, it was received by so and so. So this documents becomes handy at the time of any litigation or any time of conflict between the members or the company or ROC. So this is the service of documents. CPC has a detailed provision on service, by the way. So whenever there is a court case which goes, they have a requirement of service. So the first requirement is notice issued, but that notice needs to be served, and a proof of that service has to be produced before the court before the matter proceeds. There is also a provision under the CPC about substituted service. So say for example, if the service is not done, then what do? You publish it in newspapers, you do a substituted service. This is what are the requirements under the Civil Procedure Code. So provision may seem that why it is there. It is a simple provision. Whether there was a requirement, yes, there is a requirement because people should mention clearly. Otherwise, what will happen? One director, you give a notice to one of the directors for the company. Now company is a separate legal entity. It has to be going to the registered office, not its directors. Directors cannot take on their behalf unless in the articles it is mentioned that service to the company will be considered as proper if it is issued to one of the directors. So this is the complications. That is why this provision is very much there. There is also a case law, and this is something which you can see in different courts. There are different provisions, So if you will see, there are different provisions which are there for communication. And nowadays we are having WhatsApp. So the question came up that can there be a service by WhatsApp? So if someone says, so in a decision recently in a contempt petition before the court, one of the justices, Arvind Singh Sangwan, issued guidelines for service of notice, summons, and exchange of pleadings through WhatsApp, email, and other electronic media, and they have given details. And they were guided by two decisions of the Supreme Court. One in Krishna Veni Nigam versus Harish Nigam, and the other case was there in I'm not recollecting that case, but it is of 2020 case, wherein it was held that service to a litigant can be effected through email, phone number. However, in a criminal case, Kerala High Court held that service cannot be done by WhatsApp. So these are the situations, but I think nowadays we are all accepting electronic mode of communication, and there are detailed rules now also available in the secretarial standards for conducting board meetings, wherein proxies are allowed, online meetings are allowed. However, they need to have secure procedure. So that is a detailed procedure altogether, which we are not touching upon in this presentation. Last one section is section 21, which talks about authentication of documents and proceeding of contracts. Second last one, 22 is the last section. So it says basically that save as otherwise provided in this act, a document or proceedings requiring authentication by a company or contracts made by or on behalf of the company may be signed by any key managerial personnel, okay, which is also referred to as KMP, or an officer or employee of the company. Previously, this term was only an officer. Now it is an officer or employee of the company duly authorized by the board. So there has to be a board resolution to this effect. Okay. So which are these are the key managerial personnel. As I told you, you can see section 251. It talks about chief executive officer, company secretary, whole-time director, chief financial officer. But these people should also be authorized by the board, or board authorization has to be there that, okay, fine, chief company secretary of the company is authorized to authenticate the document or proceedings or contracts. So that resolution has to be very, very clearly there. This is just a format of a board resolution, as you can see here. So it basically clearly says that on this particular date, a resolution was taken, and such and such person having PAN number so and so has been authorized by the company to do the needful. So I think this clarifies the position on section 21. A simple section. Utility, you have understood that there has to be someone, and it is important because we talked about one provision you would recollect under Articles of Association, that is doctrine of indoor management. So it is just to save the company from the doctrine of indoor management exception, and so that people are having very, very clarity on this dimension. Then comes section 22, which deals with execution of bills of exchange, etc. So you all know bills of exchange is nothing but a negotiable instrument, right? So a bill of exchange, hundi, or promissory note shall be deemed to have been made, accepted, drawn, or endorsed on behalf of the company if made, accepted, drawn, or endorsed in the name of or on behalf of, on account of company by any person acting under its authority, express or implied. Now here it is a very important question. When we are talking, it is not only about express. Many a times implied authority is also there. So implied authority can be, say for example, any of the key managerial personnel signs a hundi or a bill of exchange on behalf of the company. It is an implied. Every time it is not necessary that there will be a authentication issued or a authorization issued, or somebody should check an authorization. Say for example, you are the CFO of a company, right? And you issue a check in which there is a company name also written and your CFO is written, and you sign and you give it. So it is basically a valid bill. It is an implied that this is the person who has the authority to sign that particular promissory note or hundi or exchange. In case of negotiable instruments, there will be always a printed document. But in case of bill of exchange, probably there may not be a printed document. So a company may, by writing under its common seal, if any, authorize any person, either generally or in respect of any specific matters, as its attorney to execute other deeds. So generally, in case of companies, there is a legal officer or a legal person who has been given a general authorization to represent the company. So they can represent the companies in India or outside India, provided that in case company does not have a common seal, the authorization under this subsection shall be made by two directors or by a director and a company secretary wherever the company has appointed a company secretary. So this is the requirement of authorization. A deed signed by such an authority or benefit behalf of the company and under his seal shall bind the company. This is the requirement. Now, since there is a common seal has been taken away, as we discussed that before in our first class, there is a requirement of this. Generally, wherever there is a requirement of signature of people from the company, it is sufficient if there are two directors who have signed, or one director or one company secretary has signed that particular document, that will be considered as valid. So this is the overall, section 22, chapter 2 concludes with this. There is a case study which I wanted to discuss with you. So this is a case where deals with the, bouncing of check. And this dispute basically originated when Bharti Airtel Limited filed complaints against, 15 telecom solutions and its directors, including Sushila Padmavati Amma, for failing to clear dues amounting to 25 crores. Okay, 25 crores odd. So here the central to the court's reasoning was. So what do you think here? Whether you know Susila Padmavati should be prosecuted or not? You can answer the query. Save as otherwise when we mentioned. So save as otherwise means basically an exception. So it is basically saying that whatever has been mentioned below, other than those things, the provision applies like this. It is the way. Okay. I'll take this example back and then I will explain you further. Okay. Yeah. Any one of you having the input here on this? Okay. I think,
Hello, sir.
yes, go ahead.
It was regarding the dues, right? That means we have utilized the services and we are not paying. They are like
No, your
creditors.
voice is very, very weak. Can you go a bit louder?
Hello, sir.
Yes.
As it is there mentioned, it is for utilization of services. We have dues and we are unable to pay. The management has not defaulted in this case, right, sir? It has not criminal default, not including any criminal defaults, right, sir? It was the inability of the company as a financial inability, can be treated as a financial
Okay.
inability.
Okay.
And
Fine. So director's responsibility is also there if they have actively participated in that decision. And that is what basically was held in this case. So the central to the court's reasoning was the distinction between holding a position as a director and being actively involved in a company's daily management. So here Justice B.R. Gavai gave this particular decision and he said, justices emphasize that mere designation as a director does not automatically implicate an individual in the operational misdemeanors of a company, right? So this is the case, Susila Padmavati Amma versus Bharti Airtel, 2024 INSC 206. So you will find multiple cases on this point, particularly criminal liability of corporations on check bounces cases. If I am not wrong, there is another case on Godfather Travels Limited. So read these cases. This will give you a broader horizon on these concepts. This is what I would say. So I think this is what completes our presentation. Now I'm open to questions. I will be happy to answer all your queries. So you can raise your hands and then we will, keep answering your queries. Okay, Hardik, you have a question? Go ahead.
Sir, in the case law, which was relating to the documents of WhatsApp, can you please go to that slide, sir?
Just a second. Give me a minute. I'll just switch off my fan. I'm not able to hear you. Yes, Hardik, tell me.
Sir, in that WhatsApp case of a document serving,
Yes. The summons.
sir, in
Document
that,
serving, we call it summons.
yes, sir, in that case law,
Service. Hmm.
there was written that passing of documents through WhatsApp was allowed.
Yes.
But sir, as per General Clauses Acts in a if you pass any kind of a document, it should be through a email. So sir, why it is written that WhatsApp is allowed?
No, because it is court's interpretation. No, they said that you have to be pragmatic and you have to be open to the newer generation changes which is happening. So this is why they have permitted. So through case law, General Clauses Act can be overruled, isn't it?
So sir, this means that General Clauses
When
Act can
General
be
Clauses
overruled if,
Act was passed, at that point in time, electronic gadgets were not there. So you
but
have
sir,
to have a
email was
constructive.
included in it. But sir,
Uh-huh.
email was included in it. In
So there
documents,
was an
when they
amendment
amended.
which made, there was an amendment subsequently which was made to the General Clauses Act to include email, no?
Oh, okay, sir. And sir, I
Yes.
have one more doubt. Sir,
Yes.
in as per section 14 and 18, both are dealing with conversions.
Yes.
of a public company and the private
No,
company.
14 is dealing with alteration of articles. Conversion
Yes,
is
sir,
dealt with
alteration.
in 18 only.
But sir, the meaning is almost same. So sir,
No, no, no.
like
Meaning
so.
is not same. See, point is that basically 14 talks about alteration of articles, and it says is situations wherein alteration of articles will happen. Generally, if you will see, major purpose of an article of association is to distinguish between public and a private company. If you will see,
Yes,
major
sir.
part. That is why it is appearing as if it is also dealing with conversion. But these are
Yes,
two
sir.
independent sections.
Okay, sir. If we will go for conversion, then we have to write section 18. If there is a change in articles, then we have to follow section 14.
Exactly.
And
And if
sir,
you change the article, say for example, you are not going for conversion, but you still change the article, wherein the
yes, sir.
effect is that the company, private company becomes a public company, right?
Yes, sir.
So then that is a problematic situation. No, you have to follow the process then of conversion. You have to move to section 18 then. Otherwise,
Sir, that was my basically doubt.
otherwise section 14 says that it will be presumed that you are moving to section 18 then.
This means that after following section 14, we have to go for section 18 if we are changing.
Yes, definitely.
Okay. Okay, sir. Thank you
Right?
very much,
Yeah,
sir.
right. Yes, Bhavna, go ahead.
Sir, what is the tribunal role in alteration of MOA and AOA?
The tribunal's role is now no more there unless there is a dispute which comes up. So if there is a dispute, then in that situation, one can move to tribunal for adjudication. Say for example, ROC is not registering something, or say for example, there is one class of creditors who is not agreeing to it, the change. Then in that situation, they can move to the tribunal for challenging it.
Okay, sir. Sir, in section 19, what are the conditions when subsidiary company not hold the shares of a holding company?
No, they cannot hold the shares of holding company at any point in time, except three situations, which has been mentioned in the section, which we dealt with.
Okay. Sir,
Mm.
explain the provision of section 16, clause 1, section 17, subsection 1, clause C.
No, come again. Which section you are asking? 16?
Section 17, subsection
Okay.
1, clause C.
Clause C. Okay. Every agreement and every resolution referred to in section. So you have to refer section 117 here. So section 117 provides you, subclause 1 provides you for a list of documents. So if you see this particular section, you will come to know which are the documents which requires to be shared with people. If I take you to section 117, let us go there and try to see. Okay. So section 117 subclause 1 lists a document. It says it specifically says a copy of every resolution or any agreement in respect of matters specified in subclause 3. Which are these? These are special resolution which have been agreed to by all members of a company, but which, if not so agreed to, would not have been effective. Then there is a resolution of the board of directors of a company, then resolution or agreements which have been agreed to by a class of members. So there are list of documents which are mentioned here. It is referring to those documents.
Okay, sir. Sir, while altering the article of association, there is provision mentioned in the MOA.
No, come again.
How to, while altering the article of association, the provision for alteration mentioned in the MOA.
No, there is no need for mention of alteration because it is a statutory provision. One can always alter it. Memorandum of association cannot constrain articles of association's amendment. Articles of association can itself restrict some clauses by retrenchment clauses. Other than that, there is no other restriction in memorandum of association. However, articles of association cannot make changes which goes beyond memorandum of association.
Okay, sir. Thank you, sir.
Yes, right. Okay. Any more questions? Any one of you?
Well, sir, can you please
Yes.
explain section 22 once again?
Section 22. Okay, sure, I will do that. So if we talk about section 22, it talks about Give me a second. Section 22.
Sir, execution of bills of exchange, etc.
Yes.
General.
Coming to that section. Let me have a look at it. See, we lawyers have got a habit of looking at the section, then only I can explain.
Okay,
So,
sir.
because every word has a meaning, you know. So
Yes, sir.
you cannot just put it across. Yes, it talks about execution of bills of exchange, right? And if you have a look at it, this is a provision which was very much there in your previous act also. It is basically corresponds to section 47 and 48 of 1956 Act. So it is basically saying that in case of bill of exchange, hundi, and promissory note, these are the three types of negotiable instruments. In those situations, anyone who draws this particular instrument or on or behalf of the company, and it can be by way of an express permission or an implied situation also. I gave you an example. For example, if a key managerial personnel signs, then it is implied that he is having the authority. Or there can be also an express authority to someone who will be signing this document. This is one part. Second part, it is saying a company may by writing common seal authorize any person to do this particular matter. So if there is a common seal of a company, they can authorize with that certificate saying that this is the person authorized to execute the bill of exchange and hundi and all those documents. Checks, anyways, it is mentioned clearly in the check that who can sign that check. Okay. So when banks issue that particular checkbook, they clearly mention these are the two authorized signatories because there is a person who is going to check in the bank. So they will not accept, right? So negotiable instrument in case of check, there is no issue because banks always check the signature. So you have to first give a certificate authorization from the company that is these are the two authorized officer who,
Yes, sir.
when they sign, then only the check will get honored. And then this is what is the explanation under section 22.
Sir, in a common seal, inside the common seal, we have to write the name of the persons who have who have the authority to sign.
Yes. Name of the person shall always be there whosoever is signing the document.
Okay, sir.
Yes. There cannot be a signature without the name of the person because signatures you cannot identify who signed it.
Sir,
But sir,
please
in case
explain
of
the
digital,
difference between bill
Yeah,
of
come one by
exchange.
one. Raise your hands first and then speak. Okay.
sir,
Yes, Bhavna, go ahead now.
Sir, please explain the difference between bill of exchange and hundi.
Yeah, bill of exchange and hundi, we have to take a negotiable instrument class. This is not subject matter of this class. Okay, Bhavna,
सर थोड़ा
what
सा
it
डिफरेंस बता देते
थोड़ा सा डिफरेंस ये है कि हुंडी जो है वो बिल हुंडी इज बेसिकली एन इंस्ट्रूमेंट विच यूज टू बी देयर in our ancient days. Okay, that is why that term has been utilized. Hundi is nothing but it is a promise to pay someone. Okay, so it can be a simple chit written. If you go to, I don't know whether you people have visited different markets. Go to some market, like for example, fruit market, or you go to the onion market, or you go to grain market. They still use certain slips for their transactions. So if they write on that this much bales of cotton delivered, so that particular paper itself is sufficient proof in those situations. That is called hundi. Bill of exchange is a proper drawn up document wherein somebody says that okay, fine, there is a amount which is to be given in exchange of some thing, some goods or something like that. That is basically a bill of exchange. So this is there under the Negotiable Instruments Act. There are different terms which are used for transactions, business transactions. Okay. So probably you will have a separate subject altogether on negotiable instrument. I don't know whether it is there with you people or not, but this is the difference, broad difference. Yes, Sai Charan, go ahead.
थैंक यू सर
Sir, Sai Kiran, sir. Sai Kiran.
No, your name is Sai Charan, Charan.
Sir, it's me, sir.
Okay,
We
go
are
ahead.
two different. Hi, sir. As you
You are
mentioned,
Sai
there is a-
Kiran, I don't know, but anyway, Sai, go ahead. Let us not use the last name.
Sir, it's as you mentioned, there is an separate act for dealing with the bills of exchange and negotiable instruments. And why this
Yes.
special provision has been brought in Companies Act that to recording? Is this a practical situations which made? Can you explain?
No, which provision you are talking about?
It's section 22, sir, by execution of bills of exchange.
Yes, 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 yes.
There is a separate act, right, sir, dealing with
Yeah, there is a
negotiable
separate
instrument.
act. This particular provision only talks about authentication, because in case of a company, you cannot see, in case of individuals, you can always identify the individual, no? But in case of a company, whom to catch, you have to otherwise lift the corporate veil every time. Here, so it is basically saying that yes, this is the mechanism to deal with the situations wherein the hundis are signed by some people or bill of exchange is signed by people on behalf of the company. So there will
Okay,
be
sir.
some presumption which will be drawn under section 2022.
Okay, sir. Following on that, if a company authorizes a manager for filing a bill of exchange, if he has been retired and a new employee came in, a new officer has been brought in, if
Okay.
that be changes has to be given to the bankers because the signature will change, right, sir, as a person changes.
Yes, yes. So
Common
that
seal
is a
might be same.
routine. That is a routine procedure which happens in company. Whenever there is a authorized signatory which changes, there is a resolution which is passed by the board and that is sent to the banks, and then that changes. There is no problem.
Okay, sir.
Okay. Yes, Sai Kiran, please go ahead. Now, there are two Sais. That is why I got confused. Now you can speak, Sai Kiran.
Now I'm Sai Kiran, sir.
Yes, yes, yes. Go ahead.
Just previously, before introduction of 2013 Companies Act, common seal was under the use. One director used to sign and other director used to affix, witness the affixation of common seal through board
Yes,
resolution. Now
right.
that common seal is not in use, so two directors have to sign all the documents. Is it correct, sir?
Yes, it is correct. And there is also alternative to company secretary. One director, one company secretary can also sign.
That loan documents also company secretary can sign, sir.
Yes, yes. If it is authorized by the board, definitely yes. Because he is a company secretary is a key managerial personnel now. Yeah.
So one company secretary, one board director can execute the
Can sign
documents
it,
on
or
behalf of
two
the
board of directors can sign it. Yes.
on behalf of the company. Any
On behalf
document
of
for
the
the
company.
company. Okay,
Provided they have a due authorization.
okay, okay.
Okay. Right. Any other questions? We still have 7 minutes.
So, in case of a company secretary, as you mentioned, he is also a key managerial person. But
Right.
as of we know, chartered accountant and cost accountant and company secretaries are the persons dealing with a professional capacity, right? So, but
Right.
here it implies that by signing in a company's official document, he has become an internal management.
No, company secretaries are always, see, whenever a company secretary is employed as an employee of a company, he is an internal management. That cannot be denied. He has to maintain the objectivity that is right of the profession, that I agree. But again, this fact cannot be gone away that the person has to report to the board, person has to, take care of the provisions. So that is always there. If he is given and authorized, then he has to sign.
So then an employer-employee
But he is
relationship
not having
exists.
any personal liability, no, sir.
Who? Company secretary?
Company. Yes, sir.
No, no, no. When they are signing on behalf of the company, anyways, no personal liability incurs unless that decision itself is an illegal decision. So whenever a company is made a signatory, company secretary is made a signatory or CA is made a signatory. CA, I don't think they are saying only company secretary because company secretary is part of the helm of affairs, right? So then in that situation, he has to be extra cautious that all rules and regulations are followed before they put the signature.
Okay. But not
Liability
personally
will
liable.
not go away. Anybody who is signing any document, their personal liability always exists.
Okay.
Sir,
Yeah.
sir,
Yes.
not offending anyone, but sir, there is no penalty for CS. All are for directors.
For?
Sir, in company law, there are no penalties for CS, only for directors.
No, for CS there is no penalty.
Yes, sir, that's what I am asking. Sir, if
No,
they
no, no,
do any
no.
fault,
CA, there are number of provisions where CS can be held accountable. CA can be held accountable. They are having their own act itself, which makes them accountable for any illegal activities which is done. That these things you will
Okay,
study
sir.
anyways. Yeah. Hmm.
Sir, so then there is an employer-employee relationship between the CS and
Yeah, Sai, your voice is very, very low. I am not able to hear.
sir. That means there is an employer-employee relationship between the CS and the company, whereas it doesn't exist when a chartered accountant was acting as an auditor to the company, right, sir?
So there can be an employee-employer relationship. There is no harm in that. And neither, I think none of these acts, says that it cannot be there.
So here a CS can be assumed as an maybe an acting as an providing a professional services, right, sir?
Yes, yes, yes. These are two different things.
Fine.
So whenever there will be a conflict of interest, those provisions are also there in the Companies Act to take care of those provisions. If you will see related party transactions provisions, this is specifically makes very, very clearly that who are the interested people. There is also a pecuniary limit provided for that.
Okay, sir. Thank you.
Okay. Anybody else has any other question? I think many of you keep quiet. Don't ask any questions. Okay. Yeah. Okay. If there are no questions, then let us call it a day. Thank you for your patience. We have completed chapter 2 of the Companies Act. I hope you people are going through the provisions and keep your questions ready. If you have any further questions, you can ask me in our next session, which we are going to have on share capital. I think you will have some other sessions in between. I am supposed to take your session on share capital. So we will talk about share capital provisions in my next session. If there are no questions, thank you. Have a nice evening. Bye bye. Happy Navratri.
Thank you so much, sir.